Okay, good morning. My name is Sherwin Long. I'm the head of the Trinidad and Tobago Extractive Industries Transparency Initiative Secretariat. I will be your master of ceremonies for today's event. I would like to welcome you all to our workshop entitled Navigating Beneficial Ownership Law in Trinidad and Tobago, sponsored by the British High Commission. This particular webinar is targeted to the law enforcement community. But before we begin, I just want to give you a brief introduction into the work of the EITI in Trinidad and Tobago. Trinidad and Tobago has been an extractive industries transparency initiative implementing country for well over a decade. And as the name suggests, our work focuses on oil, gas, and mining revenue transparency, as well as promoting accountable management of our resources. Our work really answers three fundamental questions that citizens in resource-rich countries want answered. How much do we earn from our resources? Do we get fair value? And who do we partner with to develop our resources or natural resources? This last question is really at the heart and at the center of beneficial ownership disclosure. And in the past, the TTEITI, we've developed the country's first free to the public beneficial ownership register. We've run a lot of sensitization campaigns to different stakeholders, and we've also provided recommendations to the government, to civil society, as well as companies on key facets of beneficial ownership disclosure. Analytics from the TTEITI's public sensitization campaign on beneficial ownership were used for the country's successful FATF assessment, where we were, as you all may know, taken off of the grey list. So this workshop really builds on our previous work, and our facilitators today have always shared their expertise to the TTEITI and the Trinidad and Tobago government. Just to go back a little bit, one of the questions that we try to answer is linked to beneficial ownership. But as I mentioned before, we also do a reconciliation exercise where we provide independent verification on what the country earns. So we have an independent audit firm assess government receipts and compare them to extractive company payments. So for instance, if BP pays $10 and the government reports that they received $9, this independent audit team will highlight the $1 difference, give the reason for that difference. So the work that we do also acts as an independent verification for the country's revenue. Importantly, we provide a lot of reform recommendations for the government and for extractive companies on things related to revenue collection systems, audit and assurance systems, data collection systems, and all of this is in line with protecting the people's patrimony, so to speak. So that's just a flavor of the work that we've done and that we continue to do. So far in our 8 reports, we have reconciled over 140 billion TT dollars in revenue, and we've not seen any unidentified differences. This is really important because once you have unidentified differences, then you can't account for the money that you receive. A lot of the work that we've done has provided insight into the natural gas master plan, as well as ensuring that Trinidad and Tobago meets its open government partnership obligations. So I just wanted to give you some quick highlights into the work that we do before we kick off today's session. So we've always partnered with the British High Commission on several projects in the past as well. We've done a lot of Caribbean outreach to Guyana, Suriname, Barbados, Grenada, Jamaica, countries that also have natural resources or looking to develop natural resources. And Suriname and Guyana have joined the EITI, and Jamaica is also planning to implement the EITI. So we do a lot of CARICOM outreach as well. The other projects we would have done focused on providing a gap analysis on the beneficial ownership legislation, the Company Act amendments, and other recommendations we've put in place. So without taking up too much time, as I said before, we have partnered with the British High Commission and several projects, and this is another partnership with the British High Commission. I would like to now welcome Her Excellency British High Commissioner Harriet Corse to provide some brief remarks. So I think there's some technical issues here with getting Her Excellency on. So what I will do is I will like to just introduce our facilitators today, and then we can go back to the High Commissioner for her remarks. Tim Law and Michael Barron, they have both decades of experience in law and investor relations. They are eminently qualified to provide insight on beneficial ownership for this workshop. They have provided recommendations on closing gaps associated with beneficial ownership disclosure in several EITI implementing countries. So without further ado, I'd like to hand over to Michael and Tim. Michael and Tim, over to you.
Thank you very much, Sharon. I'll start just by getting my slides up on the screen. And I hope everybody can see that. Thank you, Sharon, for that introduction. Yeah, this presentation is split really into two parts. I will present provide a bit of the context, and a colleague, Lee Robbins, who is from UK Companies House, will talk a bit more about the practical elements and how the implications for law enforcement agencies and how they can use beneficial ownership information. Obviously, Companies House, the UK through Companies House was the first country in the world to set up a public register of beneficial owners, which in the UK is called the Register of Persons of Significant Control. But Lee will say a bit more about that in a minute. Just to give you an overview of what we will cover in this workshop, provide some brief introductions, talk about the scope and purpose of the work Tim and I have been doing on beneficial ownership in Trinidad, and then provide some of the international and country context for beneficial ownership, place Trinidad and Tobago in where it sits in the global picture on this issue. So then Lee will cover kind of the heart of the matter with the kind of use case of beneficial ownership for law enforcement and the using of beneficial information. And Tim will end with kind of roundup and the next steps for you as law enforcement officials and in your role. Before I go on, just a quick disclaimer. Just say this presentation is only for information. It doesn't constitute legal advice at all, and we wouldn't want you to rely on this in any way in the course of your business or in the course of your day-to-day operations. Just to provide a bit of introduction, Tim and I are both, and Lee as well, based in the UK. Tim and I have been independent consultants for 6 or 7 years, and we were selected by Sherwin and his colleagues to undertake this work in a competitive process. This work, which I'll say a bit more about in a minute, it was basically producing a report for TTEITI and holding these workshops. This is the second in a series of 3 workshops aimed at different audiences. My background is in the oil and gas business. I worked in the government relations function for BG Group for over 12 years, during which time I had responsibility for transparency issues. And some of you may recall BG was a major investor in Trinidad and Tobago's natural gas sector before being taken over by Shell. Tim has a background in the mining industry and worked for Anglo American, the global mining company, for many years. This is actually the second beneficial ownership project we've delivered in Trinidad. About 4 years ago, we delivered a project for Sherwin and his team looking specifically at the EITI requirements on beneficial ownership. This project goes a bit further. And as Sherwin has alluded to, we've delivered beneficial ownership projects globally, not just in the Caribbean, but in Africa, Europe, and in Asia. So the work we were asked to do was, let's say, commissioned by Trinidad and Tobago EITI as part of their work to advance beneficial ownership transparency in the country and build on what they had been doing just in the extractive industry, but now taking a broader scope. So we were asked to look at the Companies Amendment Act, and particularly those sections 337A to 337D, which set up this legal obligation for companies to identify their beneficial ownership and report that information to the Registrar General. We undertook a gap analysis against international best practice, and we have submitted a report to Sherwin and his colleagues, and I'll provide a summary of that in a moment. And that includes our findings and some actionable recommendations for Trinidad and Tobago to take. And the purpose of this workshop is really to set out the international and country context, hopefully further enhance your understanding of beneficial ownership and what's happening in Trinidad and Tobago, and explain our findings and recommendations and how beneficial ownership information can benefit Trinidad and Tobago, and particularly the law enforcement community. There will be time at the end for questions and answers, but we're also happy to take questions and answers as we go along, particularly in the kind of natural breaks in the presentation. And please post your questions and comments either in the chat or in the Q&A function, and we will pick up and try to answer those, as many of those as possible as we go along. If we can't answer them here and now in this workshop, we will take them away and answer them and respond offline. Just like to kind of say, spend a couple of minutes setting out the international context. Beneficial ownership as a kind of policy issue has been around for quite some time, at least a decade, if not more. It's a number of international organizations, governments, and so forth have outlined its importance. The Financial Action Task Force, which obviously sets standards and makes recommendations on anti-money laundering and counter-terrorist financing, includes beneficial ownership as one of its recommendations, recommendation 24, and has actually recently updated and revised that recommendation. I'll say a bit about that later, and looks at not just the level of technical compliance, but the level of effectiveness through intermediate outcome, 5, part of which is quoted on the screen. NGOs like Transparency, as you expect, Transparency International and others are increasingly looking at beneficial ownership and see it as an important tool in combating corruption, conflicts of interest, and so forth. Business organizations, the B20 and others, see the importance of this and have set out principles around beneficial ownership transparency. And that's really because beneficial ownership and transparency in this area is seen as not just a tool for combating corruption, money laundering, other illicit financial transactions, which mainly your interest, but also about creating open and competitive business environments and creating a better business environment for all businesses, small and large, domestic and international. And the UK government has puts a quite strong emphasis on beneficial ownership as part of its anti-corruption strategy and as part of its economic crime strategy. And as I said, the UK was the first country to set up and operate a public beneficial ownership register, which came into force in 2016. And the direction of travel globally really is towards a greater transparency in this area and greater public availability of information on who the real ultimate owners of companies are. So EITI, beneficial ownership has actually been part of the EITI standard since 2016, but is kind of reinforced in the latest version of the standard, which dates from 2019. As I mentioned, FATF has recommendation 24 on beneficial ownership of legal entities, and then recommendation 25 on trusts and other legal arrangements, and has recently revised recommendation 24. And one of the significant revisions in the recommendation was a much stronger emphasis on central registers. And while FATF at the moment still doesn't prescribe how you make accurate beneficial ownership available in a timely manner, the current wording has more emphasis on central registers than the previous version did. But FATF does not yet advocate or prescribe a public register. The EU has also undertaken a lot of activity in this area. The anti-money laundering directives for set up the need for beneficial ownership registers, and subsequently the EU has made it a requirement of all its member states to have public registers, and is moving towards making sure those registers can talk to each other, are interoperable. And as I said, the UK, when it was a member of the EU, legislated under those directives for a public beneficial ownership register, and has also legislated now for a register of the beneficial owners, foreign beneficial owners of property. And that register, which again will come under Companies House, is due to start on the 2nd of August. Just to say a quick word about the context in Trinidad and Tobago itself. So as Sherwin said, Trinidad and Tobago has been a member of the EITI since 2011. In 2016, along with all the other 50 or so implementing countries of the EITI, Trinidad and Tobago produced a roadmap on how it would meet the EITI requirements on beneficial ownership. And in its report for the financial year 2016, Trinidad and Tobago EITI included the first beneficial ownership information. Rest of that year, Trinidad and Tobago was separately and placed on the FATF grey list, which means it's subject to certain measures and certain restrictions. That wasn't, countries are placed on grey list, as you'll be aware, not just on because of weaknesses in beneficial ownership information, but more general weaknesses in anti-money laundering measures. But beneficial ownership is a part of that. And then in 2018, Trinidad EITI produced the first public register of BO beneficial ownership, which is available online on its website. The Companies Amendment Act was passed in 2019, which has introduced these obligations on companies identifying and reporting beneficial ownership, which are implementation of that has obviously been delayed because of COVID. And then 2 years ago in 2020, Trinidad, after it had undertaken a series of reforms, was removed from the FATF grey list. And so that beneficial ownership has been an issue, or has been on the policy agenda in Trinidad and Tobago for a number of years now. And the country has made some strides toward more transparency in this issue. I will pause there if there are any immediate questions. Otherwise, I will hand over to my colleague, Tim Law, to summarize some of the recent work we've done in this area in the country.
Okay, and in the absence of any immediate questions, I will take over there, but please do feel free to raise your hand through Zoom, or put a question in the Q&A, and we will deal with those either as they come along and it's appropriate to do so, but there'll also be an opportunity at the end of all the presentations to raise any questions about beneficial ownership generally, or in Trinidad and Tobago in particular. So I'm going to talk a bit about the findings and recommendations that have come out of the report, which Michael has already referred to. I'm not going to go into those in great detail, because they talk about sort of very specific current limitations of the beneficial ownership regime in Trinidad and Tobago, and they are based on a snapshot of where the country is at the moment, and an understanding of where Trinidad and Tobago is on the journey towards beneficial ownership transparency, whereas the real purpose of this workshop is more about the use of beneficial ownership information by yourselves as law enforcement agencies, both in the future as well as where things are now. So I don't want to kind of get too hung up on exactly where Trinidad and Tobago is on its journey, but I think it's important to talk a bit about our findings and recommendations so that you understand the context in which you will be trying to operate at the moment, and also some of those recommendations for the future. The other reason is that the recommendations clearly are for government and government agencies who are implementing beneficial ownership, and so they're the focus of them. In terms of the findings from our work, first of all, it has to be said that Trinidad and Tobago has taken positive steps towards beneficial ownership transparency. Michael's just run through those on the previous slide, and Sherwin very clearly set those out as part of the work that's done by TTEITI, and then following that, the Companies Amendments Act, and what that has put in place. However, there are weaknesses and limitations in the effectiveness of the BO reporting system as it stands, both in terms of the legislative situation as we sit today, and also some of the practical aspects of beneficial ownership reporting and accessing beneficial ownership data. So at the moment, the system is relatively complex, and it does collect limited information that's relevant to beneficial ownership. There are gaps in the information which are collected. It focuses particularly on share ownership. For that reason, there are certain aspects of beneficial ownership that it misses. So it doesn't at the moment capture information such as partnerships, cooperatives, and other kind of means of control of companies that doesn't exist through the ownership of shares. And that can lead to there being some types of legal entities and arrangements that wouldn't be captured, and would therefore be potentially a loophole for people to disguise their interests or ownership of businesses or activities. There is also limited ability to access the information online and to search the data. So at the moment, data is collected through a series of manual forms which are completed and then submitted, and that information is then stored as those forms or scans of those forms within the information that is held about each company in the register. So in that way, the information isn't very readily accessible. It's not on an online portal, and I'm sure that Lee will talk about the way that the UK register works, which is probably the opposite of that in terms of the electronic populating and accessibility of the UK register. So there are some limitations. We've gone into those in a lot more detail in our report, but I think that will give you a flavour of the fact that Trinidad is on that journey, but there are still some amendments which could be made to improve the regime and make it more robust, complete and timely. In terms of our recommendations, so as I've mentioned, there are certain aspects of the legislation which don't capture every circumstance of beneficial ownership, and clearly you will acknowledge from a law enforcement agency perspective, if there is a loophole, that is what the bad actor will choose to use in order to exploit it and in this case hide their ownership. So our recommendations include one that the legislation should be amended to cover all types of legal entities. It should include listed companies having a requirement to report some information. We could talk for a long time about how beneficial ownership applies to listed companies, companies with hundreds of thousands of shareholders that change by the minute, but there are some aspects of international best practice about how some information can be captured about those companies, which provides an insight into their ownership and control. State-owned companies making some reporting. At the moment, the Trinidad and Tobago regime as set out in the Companies Amendment Act doesn't set a threshold for ownership at which beneficial ownership reporting is triggered. So however small the interest a person may have, directly or indirectly, in a company in Trinidad and Tobago, there is a requirement for them to complete the paper forms that report beneficial ownership. Although that may seem like the most comprehensive and complete way to approach beneficial ownership, it isn't, because it potentially undermines the credibility of a regime because of the compliance and verification burden that places. So we've also recommended that a threshold would be appropriate, and that there should be reporting of information about what are known as PEPs, politically exposed persons. So the business interests of people who are in a position of political influence should have greater levels of transparency than the members of the general public. We've also recommended that the data collection should be simplified through electronic submission through an online portal and electronic filing. And similarly, jumping to the last one, that there should be a public register which is also accessible online. So an end-to-end online solution which allows public access to beneficial ownership information. The third one, we've also recommended that there should be more strategic communications and outreach to those companies that are reporting. Michael alluded to the fact that this is one of a series of 3 workshops. The first workshop was with the private sector. It was with companies and representatives of companies who are subject to beneficial ownership reporting. And what became very clear during the course of that presentation was that there is a real need and desire for more training, explanation and support for private sector businesses who are reporting. That's important from a law enforcement perspective because the quality of data and identifying the difference between businesses who have misreported their beneficial ownership simply because they didn't really understand it or know what to do, and businesses who are deliberately masking their beneficial ownership for criminal or other intent is obviously an important part of moving towards using this information for the purposes of law enforcement. So those are our key recommendations. I will now pass over to Lee. So we are delighted to have Lee with us here today from Companies House. He has a wealth of experience at Companies House, including being specifically involved in the legislation for the persons of significant control regime, which is what the UK calls beneficial ownership, and setting that up. He's also been involved in the UK's FATF assessments and the implementation of the EU anti-money laundering directives. He now is working on, and I'm sure he'll talk about this, some further challenges in Companies House to improve systems quality of data and accessibility. But I'll let Lee introduce himself, and I think he's also got a slide deck that I'm sure he'll want to share.
Great, thanks, Tim. Can everybody see my slides? Yeah, okay. So yeah, thanks for that introduction. Yeah, it's been really interesting to hear about what's been going on in Trinidad and Tobago. And on a personal level, myself and a colleague came out 3 or 4 years ago when the legislation was being implemented in Trinidad and Tobago. I met Sherwin and some colleagues within the Trinidad and Tobago government. So it's great to see that you've come off the grey list and that things are moving in the right direction. So the focus of today's session, as Michael and Tim have said, is around how beneficial ownership information is used and can be used by law enforcement colleagues. So I'm going to give you some insight into my experience of working with law enforcement partners in the UK. I'm going to start off by just giving a little bit of context to how things are in the UK. First of all, a couple of statistics just to set the scene. So there's been a few references there from Tim, particularly in terms of the importance of how accessible the information is and how transparent it is. Prior to the introduction of beneficial ownership information in the UK, we made a really bold step as a registry to make most of our information free of charge back in about 2014. And that has made a significant difference in terms of how scrutinized the register is. The fees that were in place prior to that timeline were pretty nominal, but they were a barrier to the information. So if people were doing a search at the time on who the director of a company was, or wanted to see the latest accounts, they'd have to get their credit card out and pay £1 sterling to access that information. It may not be a lot of money, but it was something that they weren't motivated enough to do it. Whereas now we're getting, we had 10 billion transactions on our systems last year in terms of searching the information. So making that information free has made a massive difference to how widely the information in Companies House is used. Just in general terms, we've got just under 5 million companies on the register, and in terms of beneficial owners or PSEs, it's just under 6 million. It's very close to 6 million PSEs on the register. Most years we're incorporating somewhere between 700,000 and 800,000 companies, with 400,000 to 500,000 companies coming off the register as being defunct. So we've seen sustained growth in the overall size of the register in the UK for a number of years, with a very few exceptions. If I take that one step closer in terms of the interest in the information, as I've said, it's really accessible to get hold of that information. And quite some time ago, I took a personal interest in how many views there are of the PSE information. So I get a report from colleagues internally on a monthly basis telling me where those searches are, so I can even say what countries they're coming from. But yeah, it's in the region of, I think it's just over 650,000 searches just on beneficial ownership information last month, and that's pretty consistent. There's probably a slightly upward trajectory, so I wouldn't be surprised if it'll be up to 1 million before the end of the year. Very, very briefly, the story in the UK at the moment in terms of beneficial ownership information, and some of these things have already been touched on by Michael and Tim. It started off as part of our commitments in the G8 summit when the then British Prime Minister, David Cameron, made a commitment to shine a light into the dark corners and to identify who was pulling the strings behind all companies. There's a lot of work that then took place in terms of looking at that trust and transparency agenda, and as we've already said, the world's first public beneficial ownership register was launched in the UK in 2016. We took an approach where initially there was pretty much a 12-month transition. So we linked the initial filing of beneficial ownership information to the annual report that the company submit, which at that time then was changed to the confirmation statement. And it meant that every company on the register at the time had a particular touch point over the course of a year where they would always contact Companies House and provide an update. And for that year between 2016 and 2017, we made it an additional requirement for them to provide their first PSE information. That was fairly successful, and we had well over 80% of companies that complied during that 12-month period. That then left still a significant number of companies who hadn't provided their PSE information. And in 2017, when the fourth money laundering directive came in, it changed it from an annual requirement to submit beneficial ownership information to a real-time event-driven requirement, whereby whenever a company changes its PSE or its beneficial ownership details, there needs to be an update in their own company registers within 14 days and a notification to the registrar within a further 14 days. So the information on the register in the UK should always be up to date, and it's a criminal offence if it isn't. And I'll touch a bit more on the criminal offence side of it later. We had an interesting experience around the Financial Task Force evaluation in 2018, and although it was far from perfect, it did come out as one of the best assessments that had been done by any country at that particular point. So it was something we were all really pleased with, who were involved in that process. And immediate outcome 5 around beneficial ownership information, although there were some concerns that we didn't verify information in Companies House in the UK, there was still a lot more that was really, really good and world leading about what we were doing, but with some room for improvement. And I'll touch on what we've done since then to sort of cover some of those areas that FATF would have been concerned about. One of the steps forward from that point was, under the 5th Money Laundering Directive, there was a new requirement for any firm that is regulated under the money laundering regulations in the UK, where they carry out due diligence to onboard new clients. As part of that process, from January 2020, it became a legal requirement for them to compare the information on the public register with the information that they were getting from their new clients. And if there was a discrepancy, there was a legal requirement to report that discrepancy to Companies House, and for Companies House then to investigate that and look to correct that information. And you know, that's we've had sort of significant number of discrepancy reports since it started in 2020, and it's helped a lot in terms of improving the quality of that information. And then very finally, bringing things right up to date, as Michael mentioned, I think on his slide, we have a new chapter in beneficial ownership information about to be implemented in the UK. Something called the Economic Crime Act came into force back in March, and the enabling regulations have recently come in, which means that from the beginning of next month, any overseas company that owns property or land in the UK will need to provide details of their beneficial owners to Companies House. And if they don't, then there's the intention that the UK land registry will essentially put a freeze on those assets, and they're not going to be able to do anything with those assets until they provide their beneficial ownership information. So that's a very new area of work, but it's something that's going to be, you know, fascinating to see how it unfolds over the next year. So coming back to when the PSE information was implemented in the UK, and it's interesting to see some of the recommendations that Tim made there about the position in Trinidad and Tobago. In the UK, almost all of the companies that are on our register, I think it's something like 95% of the entities that are on the register are covered by the regime. The main ones are the public, private and public companies, the limited liability partnerships, and a couple of other different partnerships, particularly the Scottish limited partnerships that were brought into scope in 2017 as a reaction really to the criticism that they were being particularly misused as a vehicle for being involved in some of the laundromat cases that were reported during the period between sort of 2016 and 2020. There are some exceptions. Again, this is something I think that's common with the position in Trinidad and Tobago. It's on the perception that there's an awful lot of information already out there that is available on listed companies, but I think we have learned some lessons, and I think as we look to reform the legislation in the UK, that's an area that we intend to strengthen to add some greater transparency, because I think although the information is available on things like the London Stock Exchange and various other sort of regulators like the Financial Conduct Authority and so on, it could still be easier, I think, to trace that beneficial ownership information. So I think we're going to be looking to do some work in that area. Very basically, companies have got some, well, they've got a big obligation, first of all, to identify who the PSE is of the company. And the Companies Act in the UK gives those companies powers in order to obtain that information. So if I'm the company secretary or somebody running a business in the UK and it isn't straightforward and it's complicated, there are some powers I can rely on in the Companies Act to issue some official notices requesting information, and the non-compliance with those notices could result in a criminal offence. So there are many sort of levers and gears that companies have to obtain that information. Just to point out, although transparency is really important and making that information is really important, there is another side to things, and we do have a protection regime in the UK. So if somebody wants to make an application to have their details suppressed or withheld from the register, there are some tests that can be applied for that to happen. In those circumstances, that information would still be potentially available to law enforcement colleagues, but it would be withheld from the public register. Non-compliance with these obligations is a criminal offence. I've mentioned this a few times, and getting the guidance right is really important. We've got lots of guidance on our websites with regards to the detailing all the various obligations for PSEs. I'm not going to spend too much time on this, but these are this is the definition of the conditions that have to be met in the UK for someone to qualify as a beneficial owner or a PSE. The first three conditions are fairly self-explanatory. The key thing here, there's got to be more than 25%. I know it's different in some other countries and some other jurisdictions, and that goes for the shares and the voting rights. Also, if an individual has the right to appoint or remove the majority of the board of directors. The fourth one is a little bit of a catch-all and only really applies if an individual is still able to exert influence and control, but doesn't meet any of those first three conditions. So we even produced some additional special statutory guidance that was debated by Parliament in the UK, just to sort of define a little bit more detail in terms of what we mean by that significant influence and control. So that's something that you can have a look at online. And then the last one is more of a niche area, and this is where any of the other conditions are met, but it's through a trust or a firm. So it's more of an indirect type of control. So getting on to the main things that I really wanted to cover in today's session, in terms of what we do in the UK in Companies House in terms of working with other partners, but particularly law enforcement. We are members of something called JMLIT, which stands for the Joint Money Laundering Intelligence Task Force. This is something that the National Crime Agency are responsible for heading up in the UK, but it's very much a partnership of government departments, law enforcement colleagues, but also very much private sector and civil society groups. and they're all able to come together under a legal gateway within the Section 7 of the Crime and Courts Act in the UK, which allows for a franker way of working than would otherwise be possible. So very much normally from a company's house point of view, one of our great frustrations is that we are very good at working with partners when it comes to responding to things on a reactionary basis, but we don't really have the right purpose and the right legal sort of structure for proactively identifying suspicious activity and identifying criminality on the register. These are things that we're looking to address in terms of changing the legislation that governs us in the UK. And I will finish my presentation by giving you a little flavour of what we're hoping to achieve with that. But back to this. These groups, as I said, are focused or led by law enforcement colleagues. Typically, you'll have members from some of the large banks, and there will be discussions about various typologies. There may be concerns about all types of economic crime, money laundering. Some of these groups are very much on a strategic footing. Others are far more operational, where actual cases and things will be discussed. So yeah, I think that's something that in my experience of working in those situations, it is something that is really powerful and really effective. I think if you go, you could actually Google Gimlet, and I think there are some results there that would give you a bit more about how that group works in the concept. Coming back to the enforcement position for a few moments, from within Companies House's own inward-looking situation. When the legislation was introduced in the UK, we had something like 25 new offences that related to PSE or beneficial ownership requirements. Some of those are very low-level technical offences, but there are others that are more serious. The most serious cover the potential for a custodial sentence and unlimited fines. So it ranges at the high end with that sort of thing, down to other offences where perhaps a level 1 fine of £1,000 might be the maximum fine. Over the course of the last sort of 4 or 5 years that we've been proactively doing enforcement action around PSE obligations, I think we've had over 400 convictions, and we regularly have sort of a court hearing on a monthly basis. Takes place in London generally, where we have a hearing that is specifically to deal with PSE prosecutions. So that's something that's very good, and probably not unrelated. We're now at the position where 99.8% of all companies that are within the PSE regime in the UK are compliant with their responsibilities. With such a big register, that does mean there are a few that we still need to chase, but we're always on the case with them. So coming back a little bit more now to the law enforcement stuff again, and I mentioned that our powers in the UK don't allow us very easily to proactively provide partners with information, but reactively, this is an indication of where we are. So back in 2016, we were dealing with less than 2,000 requests during that year from law enforcement partners to help with ongoing live investigations. Last year, or 2021, that went up to over 9,000, and this year it was over 11,000. So these are all requests that have been made from law enforcement partners using a gateway. generally the Data Protection Act or some other law enforcement gateway. And as I said, it's significantly grown. In terms of the beneficial ownership information, in 2016, 2017, when the register first came in, very few of those requests would have included beneficial ownership information. In the last 3 years, almost all of those requests will have an element of beneficial ownership information in them. It's rare for them to be, for law enforcement to come to us and only inquire about the beneficial ownership information, but it's seen as one of the key component elements of information that they would request from us, along with other information. So we've seen a really big increase in the number of requests that we've had from law enforcement partners. Just flash that up for a few seconds. This just gives you an indication of the breadth of people that we're now working really regularly with in that sort of law enforcement space. This screen includes some feedback that I've had from law enforcement partners, particularly on that third section there. But also over the last few years, we've done a lot of strategic stakeholder work with different groups, including sort of civil society and other sort of sectors, whether they're sort of the accountancy sector or the legal sector, as well as general users of Companies House information. So there is a real sort of recognition from civil society groups and investigative journalists that the fact that they can easily access the information on our website is a huge positive. But not only that, they are also able to download the information in an API and consume it into their own databases and carry out data dives in a more sort of complex way. So for those firms that are interested in doing that type of behavior, then we provide them the means to do that. And I think civil society groups, particularly in the last few years, have become what I would call critical friends to us in the registry in the UK, whereby probably a number of years ago, there would have been lots of reports published about how poor the quality of information was in Companies House, or how things needed to improve. We've engaged with them, as I said, a lot more in the last few years, and it means that they're still keen to provide sort of constructive criticism and challenge, but it's done in a way whereby it's something that we can work together to try and address. So I think those things have come on a lot in the last 3 or 4 years. So the law enforcement stuff, I think, are things that are going to be particularly of interest to you. And these were some of the comments that I captured from, as I said, some colleagues a little while ago. So first of all, the fact that the information is available on our website, the basic beneficial ownership information, it's quick, it's easy, and it's quite all encompassing. And because there's such a high compliance rate, there's lots of information there. They don't need to obtain court orders and official requests. So when they're starting off looking at things from a basic research or trying to develop intelligence, then there's quite a lot of information that's available to them. If they then do need more information, and that comes back then to those requests I showed you on the graph on the slide before, they've got a much greater idea of what information it is they want. So it means that they're making better requests for that information. In terms of the information not always adding up with what they would expect, the feedback I've been given is that is sometimes a useful hook for their investigation. So if a bad actor has actually provided false information to us in the registry, it isn't always a bad thing from the investigator's perspective, because they can use that to see where there's been consistencies or inconsistencies in terms of other data sets that they may have available as part of their investigation. And this is not just down to individuals who may be PSEs, but also the sometimes professional enablers who are behind some of the filings of this information. That can sometimes also be very pertinent to an investigation. And then finally, one of the things that they mentioned that was really, really good about Companies House was that bulk data that I mentioned. So there are several ways of obtaining the bulk information from Companies House, which gives law enforcement and others different opportunities then to crunch that data and to use it in different ways. If they request bespoke reports, then that's something that we're very good at dealing with. So, you know, if they wanted to know how many beneficial owners there are with an address in Trinidad and Tobago, you know, that's something that we could easily run off and provide to law enforcement colleagues. So, you know, so there's those sorts of things. Also, actually, earlier this year, there was an update to the advanced search feature on our website, which now makes our search function on our website much more powerful than it was before, where you can actually use different types of categories to drill down on a search. So if I wanted to know every company that had a certain standard industrial classification code and was based at a certain postcode and that had filed dormant accounts, I could do that search just on our website now, and there are a number of different ways of carrying out that sort of search. So again, although some of these users, professional users, are downloading all of the information and doing lots of that clever stuff themselves, we've also provided the tools so that lots of that clever stuff can be done simply from our website. Okay, so that's sort of talking quite generally. What I'm going to do now is spend a little bit of time talking about a particular case study that refers to where beneficial ownership was a key element of the case, and then I'm going to finish off by talking a little bit about some of the things that are going to change in the UK in terms of changing the way Companies House as a registry operates. So first of all, the case study. A few years ago, there was a widely reported case in the UK. So some of this can be, again, researched online. So I'm able to talk about it quite freely without needing to sanitize it too much. There were funds that were transferred from a Cayman Islands company called AWAC Holdings to a young student called Vlad Luka Fila. Now, he was the son of the former Moldovan President Vladimir Fila Sr., who had previously been convicted of some corruption offences relating to banking fraud in Moldova through some banks in Latvia. Now, as part of the picture, when the investigator was looking at this, it became apparent that there were some overseas companies in the Cayman Islands and Turkey who had paid large deposits into 3 different bank accounts that were held by the young man, by the student. So during the investigation, it was carried out by the National Crime Agency in the UK. They made a request to the Cayman Islands via the Overseas Territories Ultimate Beneficial Ownership Exchange Scheme. Now, this information was provided back to the investigator and it was used during the court proceedings, which involved a sort of the obtaining of a successful forfeiture order under the Proceeds of Crime Act. During the case, the NCA successfully argued that the funds had come from this Moldovan bank fraud, which the father had been convicted of through corruption offences. The judge in the UK granted the order, and just under £500,000 sterling was forfeited. In this case, the information that was provided through the UBO, the ultimate beneficial owner exchange system, was a really important element of the investigation and allowed the investigators to take a particular course of action in terms of identifying how people's relationships were linked, in clarifying how that money had gone into the account. So that was all quite successful. Interestingly, I noticed that last year the confiscated money was actually returned from the UK to the Moldovan government. So it was initially forfeited and passed back to be used, I think, to recruit care workers, if I remember rightly from the news story. So that's an example of internationally how there is sometimes, how crucial, I suppose, the identifying of the beneficial ownership information can be, and how it can be successful. I think in the UK position, there's lots of cases that are ongoing. Some of them have a really long lead time, and while the investigations are live, we're unable to sort of comment on them. But I think the point that I made earlier also is quite true. That it's quite hard to pull out cases where it's only the beneficial ownership information that is crucial. Now it's just an integral part of the case. So it's almost in every case where we get a request for information in Companies House that law enforcement will want that sort of information. So that's the case study. I think this is my last slide. So I'll finish it there and see where we go in terms of questions or where Michael and Tim want to go with things. There's been some references to the fact that, and I've made those references myself, historically the register in the UK, in Companies House, has been one where we have often used the phrase of accepting things in good faith. And that's probably one of the main sort of principles in terms of our historic legislation that sort of supports our system. There's been a lot more pressure in recent years to take a more assertive approach to company registration in the UK. We still want to be a good place to do business. We still want people to be able to quickly and inexpensively set up companies, and to be entrepreneurs and to have that inward investment into the UK. But we also want to make it more difficult for those who abuse the corporate vehicles that you can obtain in the UK. So these are some of the key elements of the reforms that are currently going through Parliament, and we may well, towards the end of this year, early next year, see these things actually coming into force. The one big thing is going to be the identity verification of directors and PSEs, as well as presenters of information. So all of the 7 million directors and nearly 7 million PSEs will have to, over a period of time, retrospectively be verified, as well as all new directors and PSEs and presenters as we go forward from the point that the new legislation comes in. So that's going to be a massive job, but it will definitely give people a lot more confidence in the data that we've got on the register, and that's going to be useful for law enforcement and various other partners who are using our data. The other thing is we're going to have some new powers to query and reject filing. So I just mentioned that a lot of what we've been doing historically has been based on the fact that if you filled everything in okay, then we accept it in good faith. In the future, we could be working on intelligence from law enforcement partners or other government departments whereby we've got concerns about something, and instead of simply accepting everything because it's all filled in correctly, we could be in the position where we're able to put the brakes on and go back to the whoever submitted that information to ask them to provide additional information to satisfy us before we're willing to accept it. So that could occur before we accept something, or we could even go back and challenge something post-registration as well. Data sharing is a big thing. I mentioned Gimlet as a really useful way that we currently are able to share some information, but it could be a lot better. So the new legislation is going to do a lot so that we can share the right information with the right partners, and not only do it on a reactive basis where we've had a lot of success, but also proactively. You know, one of our big ambitions is to use technology to scrutinize our own data so that we can identify suspicious activity and share it with the most appropriate partner. So that, yeah, that's a really sort of exciting thing that I'm really looking forward to. And then just to also mention that although there's a lot of transparency and there's a lot of sharing and there's new powers, we've got to keep that balance in mind in terms of making sure that the privacy protections are also appropriate as well. So there'll be some new things that will come in that will enhance the provisions that are already in the Act. So yeah, that's the end of my slides. Hand back to Michael or Tim.
Thank you, Lee. That was a fantastic presentation. And while you were speaking, a couple of questions have come in, which we will take and post in the Q&A. So the first one is from Nicole Singh, who asks, what measures have been used to achieve such a high percentage of compliance?
Yeah, okay. So what I would, I suppose, need to be transparent about is that the compliance rate is worked out on the basis of those who are compliant with the legislation. So the legislation in the UK is that you either need to tell us who your beneficial owner is, or you need to tell us that you don't have anyone who meets that requirement. So you could make a statement to say, we've done our information gathering, we've really researched everything, or perhaps simply that, you know, that there is an example whereby either by design, if somebody's trying to get around it, or it could be quite genuine. There could be a setup where someone has got 5 individuals who all have an equal share in everything, which means that nobody breaks the more than 25% threshold. So that is an example. So the reason I mentioned that is that it would be unfair of me or disingenuous of me to say that we've got 4 million or 4.8 million companies who have all provided their PSE information. What we've got is that number that have complied with their responsibilities to tell us something. So there are several 100,000, and it is only several 100,000 as opposed to all of the register, but there will be a significant number of companies where, because this is legislation that applies to everyone, because of the setup of that particular company, there will be some circumstances where they can legitimately hand on heart say, I haven't got somebody who meets the criteria or the conditions to be a PSE. Just rolling back a little bit, I know I'm giving rambling a little bit in terms of my answer, but to give the answer that was probably expected, we also did have to put in quite a lot of effort in terms of having a pursuit process. So that was semi-automated. So as companies were first scrutinized through our internal systems, where we could see that they hadn't submitted their information, we were able to initially start off with an automated process for a few stages. That had a certain success level where, you know, if we issue 10,000 letters, 50% of the companies may well respond. And then as we sort of drilled down, the process then became more and more manual. And the cases where once we'd exhausted those processes, this is where the prosecutions came. So I mentioned that there have been several hundred prosecutions over the course of the time. And, you know, that in itself, I think, aids the messaging of compliance in a way. I think if the companies are aware that there is a real chance that they could get prosecuted, then that can sometimes be a motivator as well. So a number of different things. So first of all, understanding what the 99.8% means, but also, you know, quite a lot of work in terms of the initial compliance pursuit and then the escalation to prosecution where appropriate.
Just before I go on to the next question, just and I'll come to Janelle in a minute who wants to ask a question. But on compliance, one of the things, well, first of all, as a beneficial owner who has to comply with the UK register, but also having looked at other countries' registers around the world, one of the other factors that aids compliance is making sure that the system for reporting information is as simple and straightforward as possible. And also that, and hence also our recommendation about electronic filing, but also our recommendation about communications, making sure companies and those who act on their behalf, like accountants and company registration agents, understand what the obligations are. And that's one thing I think that's contributed to the high compliance rate in the UK system, is the kind of ease of use, the ease of supplying your information, and a kind of clarity on what your legal obligations are.
Yeah, so, just worth saying, I think that although it isn't mandated in the UK, I think we do have a really high take-up of online filing. For the PSE information in particular, it's in the high 90%. So I think it's somewhere around 97 or 98% of all PSE information is submitted online. And you're right, it's a very straightforward, intuitive journey, particularly if you compare it to the forms, which can be a little bit tough going of picking the right form in the first place, then ticking the right boxes. So for more people who take that online intuitive journey, then yes, I agree. It does make it simpler to provide the information.
So next question is Janelle. Go ahead, please ask your question. I think you're still muted, Janelle.
Yeah, sorry about that. That was done in error.
All right. So you didn't actually mean your raising your hand was in error, was it? Okay, fine. We can go on.
Right. The next question from Wendell Lucas. Do you have a working document that informs the relationship with the vast number of partners you work with?
Yeah, I think there's something that we can share. There may be something in our last sort of accounts that were published, but also we've got a sort of a senior strategic stakeholder manager, and you know there's a sort of a strategy for our approach there. So I can't say 100%, but I can definitely look into that and provide something that can be circulated again if it's something that can be, you know, is helpful.
A question from Christopher Emrath. Can you say the most common ways people use beneficial ownership to gain interest or obtaining money?
So I think, you know, what sometimes happens is that you have situations where organized criminals will either sort of set up a company themselves, and because we're not currently doing that identity verification, it's something that, you know, can happen fairly straightforwardly. And in those cases, they may have either nominees in place or complicated structures or fabricated details. Now, in one sense, as long as they submit, or as long as they go through the process of submitting all the filings that they should, and they don't draw attention to themselves, then from a company's house point of view, it appears to be a good actor. One of the great things about the UK system, though, is that because it is on such a public register, you do have the many eyes on that information, and it means that if people see that information and become aware that it is a bogus company or a fraudulently incorporated company, then you know, they can either make a referral to law enforcement or to Companies House. In other sort of exceptional cases, we've seen hijacks take place where you've got existing companies, or sometimes companies who are perhaps on the path to being dissolved, where again organized criminals will try and sweep in and take over those companies to use either for a sort of short-term fraud or money laundering or some other case. And you know, updating some of those details, whether it's the beneficial ownership information or the director's details or the registered office, these are all things that can play part of it.
You're on mute, Michael.
Sorry, one more question on the similar theme. What can be done to deal with errant shell companies that are set up depriving taxes to government as well as benefits to employees and form part of bid rigging?
Yeah, and I think this comes very much into the territory where I mentioned from a Companies House perspective in the UK, sometimes we are frustrated that we can't be more proactive within our current legal framework. What we want to do is to use sort of artificial intelligence and data science techniques to build in those checks into our systems so that we can identify shell companies being set up and work with the right partners to try and either disrupt or prevent and sort of use the general sort of 4 Ps the law enforcement would refer to. One of the areas where we have had some success in the UK, but it was very much as a pilot, was where something called the Digital Economy Act came in a few years ago and allowed for the exchanging of information where there was risks about potential fraud or error. And we did an exercise with a couple of partners, but particularly with Companies House and the tax office, HMRC in the UK. And what we did was we looked at all the companies that had filed accounts over a 4-year period, and we compared what they told each of us to look for the differences. And the amount of tax evasion and things that we discovered was, you know, it ran into there was millions of pounds of tax that for the tax office to follow up on. Also, interestingly, there were a number of sort of fictitious companies that have been set up where they had no tax footprint at all. However, they appeared to have a company on the register that looked like a bona fide company that had obviously been set up for some sort of illicit purpose. So, you know, there is a real big value in being able to share and compare data when you've got the right legal gateways to allow you to do it. So yeah, I think there's more of that to come, I think, further down the line.
I think just to add to that, one of the uses we've seen in countries around the world for the use of beneficial ownership information, particularly by government agencies or public agencies, is in public procurement contracts demanding that bidders provide their beneficial ownership information as part of the bidding process, as part of the documentation, and that can be checked against the register or verified in some other way. And similarly, when governments are awarding, and since we're being hosted by Trinidad EITI, when governments awarding licenses for exploration or exploitation of minerals, again, that they provide beneficial ownership information as part of that bidding process, and therefore there are penalties, including voiding the contract if those details are later shown to be false or there's been some kind of other criminal activity. A couple more questions before we move on, unless more appears. Another one from Nicole Singh. What would the verification process entail? I think you're talking about the new powers that are coming in for Companies House.
Yeah, so I don't think we're looking to sort of reinvent the wheel. I think we're looking at what there is a UK government system, I think called Verify, that we will look at, but I think we're more likely to go to a third-party supplier in terms of somebody who currently does identity verification for banks and others. So it'll be very much along the lines, I would imagine, of some sort of photographic ID and some sort of process online where they'd need to record a little video or something. So yeah, it's, I suppose one of the things to make clear is that what we're not going to be able to do in the first instance is to verify that that Michael is the beneficial owner of his company. What we'll be able to verify is that Michael is Michael, he is a real person. And although that might not be as comprehensive as some would like, it's still a really sort of big step change to us just accepting things in good faith. So yeah, as I said, I think we're still exploring who would actually do it, but I think we're looking at some sort of simple process where the vast majority of people would be verified or not, just in a very simple couple of minutes. But there will be some complications to that. So, some people perhaps who are not UK based, there may be some more work to do in terms of verifying their identity. But what we're led to believe by some of the people out there who sort of specialize in these fields, that that there are databases that are able to do all of this sort of stuff, and also to take on board the fact that even if people don't have the photographic ID, there'll be other ways of doing it. So yeah, it's yeah, and like I said, the other element, particularly in the transition, because remember what I said, we're going to be starting from the position of probably people going forward will have to verify as they come onto the register for the first time, but we're going to have all this unverified information that's already on the register. So after some sort of transition, I think what we're going to start to do is to annotate the records to make it very clear where information has been annotated, or where information has been verified or where it hasn't. And I think that may well motivate some behavior as well as there being possibly some sort of sanctions involved in terms of if people don't verify their data, then there'll either be some sort of criminal sanction or a civil penalty of some sort.
And one final question, which is basically something you talked a lot about, the balance between how do you balance the privacy concerns with the need to know. That was from Andrew Matthews.
So there are some particular measures in the proposals that have been sort of consulted on and are in the Economic Crime Bill 2 that's in Parliament at the moment, around certain circumstances where people have a potential right to have their information suppressed. So going back a number of years ago, we introduced a level of suppression whereby residential addresses and a full date of birth were not routinely available on the public record. there's enough information there to identify one John Smith from another John Smith in terms of the month and year of birth and a service address, but some of that information is held back. It is made available to specified public authorities such as law enforcement and other government offices on request, but as far as the public register is concerned, there is an element of helping to reduce the idea of identity theft and so on. At the same time, there was also some powers brought in whereby people who had made that information, people who had information on the record going back to a certain time could apply to have their details suppressed from historical data once they were no longer a director of that company. So if you go onto the Companies House website, you'd only get the current position, but the paper documents going back 20 or 30 years or whatever would sometimes mean that somebody could find information if they tried really hard. So there are some circumstances where having that is going to be part of the new proposals. One area that we're particularly looking at is signatures. Again, something that can be misused in terms of identity theft and identity fraud and things, and looking at where, if there are historical signatures on our records these days, where much of the stuff is filed electronically, then you don't have that as an issue. To even things up, we're going to be allowing potential for people to apply in the right circumstances to have some of that information suppressed. There would, it's worth pointing out that there'd be a cost associated with that, because it would be quite an onerous process for us to go back and find all this information to suppress it. We wouldn't be looking to make any sort of profit out of that work, but we would need to come up with a fee that would recover the costs of doing that sort of thing.
Thank you very much, Leah. Let's pause and catch your breath and hand over to my colleague, Tim. We'll just finish up, and then we'll have some words from the British High Commissioner, Harriet Cross. So Tim, over to you.
Thanks very much, Michael. Too many buttons I had to click there, sorry, but I've got there now. Thank you very much for all the input there from Lee, and also from all those who asked questions, and Lee and Michael in answering them. And I think to sort of wrap up our inputs to this, there are a few points of call to action that we think are worth mentioning. So the first of those is that I think it's important to become familiar with how to access the Trinidad and Tobago BO register. So what the process is to access information and gain access to that information. It's important to understand the information that is available in Trinidad and Tobago's register, and also what isn't. And that's really part of understanding the use of that information, understanding what gaps there are, and observing how things move forward. Because as I mentioned early on in this session, every country is on a journey of developing and implementing beneficial ownership registers. Even the UK, which has been on that path since 2016, in fact been on it since long before then, when the register was first conceived, but 2016 when it became live. And Trinidad and Tobago is on that journey. So it's important to understand what information is currently available and what isn't and might become available in the future. It's also important to understand what information is available on other countries, other jurisdictions' beneficial ownership registers. As soon as a corporate structure, which might be subject to some kind of investigation, becomes international, then there will be companies within that structure sitting in other jurisdictions. An increasing number of jurisdictions are implementing beneficial ownership registers. And so there may well be information which is available through registers in other jurisdictions, whether it's the UK or whether it's an EU member state, which since the adoption of the EU anti-money laundering directives 4 and 5, all EU member states should have public registers of beneficial ownership. So whether it's one of them or whether it's somewhere else in the world that's introducing a register, it's important to understand that the Trinidad and Tobago register is not the only source of information. There are also those other international registers which are important. It's also important to understand how to access the information from those registers. That obviously is a combination of, in some cases, freely accessible data, such as the UK register, which you don't need to be to have any special authority to access. You can just log on and look for information, or information which can be gained through agreements for exchange of information between the governments of different jurisdictions in order to be able to further investigate the beneficial ownership of international structures. It's also important to engage with the Attorney General's office around the upgrading of IT systems so that access to BO information can be that much more efficient and effective. And I think, as with any project of this type and challenge of this type, it's always really important that that there's a clear understanding of not just the current use case and applicability of initiatives and work that's being done, but also the opportunity that there is if that information is more readily available, easier to access, and available on a more timely basis. So I think it's important from a law enforcement agency perspective to keep close to the work being done by the Attorney General's office to ensure that the use case which you see for beneficial ownership transparency continues to be a driver for improvements in systems and increasing the way in which information is collected and shared. So those really are our calls to action. So I am aware now that I believe the High Commissioner wants to say a few words. So I will stop sharing that and hand back the floor to either Sherwin if he wants to make an introduction, or directly to the High Commissioner if she wants to speak first.
Thank you very much, Tim. As you know, as I said before earlier, we have a history of partnership with the British High Commission, and I would now like to welcome Her Excellency Harriet Cross to say a few remarks. Thank you.
Thank you very much. Good morning, everybody. Let me say all protocols observed. Thank you so much for inviting me to say a few closing words, and it was great to get the opportunity to listen to some of the workshop as well. Let me start by saying thank you so much to the Trinidad and Tobago Extractive Industries Transparency Institute. It's really impressive that you've taken on the responsibility of pushing forward this issue of beneficial ownership. Really important work. And I also want to commend all the law enforcement agencies who are represented here today. You're all doing a really tough job in difficult circumstances. Thank you for all that you do to keep us safe in so many different domains. And let me say a particular thanks to the UK presenters. I've really enjoyed listening to you speak this morning. Thank you for sharing your expertise with us. As I've said, this work is really tangible action in the critical and ongoing fight against corruption, whether this is money laundering, financing of terrorism, tax evasion. And as you'll have heard today, establishing registers of company ownership is a really powerful transparency tool to deter criminals from hiding the proceeds of their crimes as much as anything else. And the money we're talking about is huge. The World Economic Forum estimates the global cost of corruption to be at least $2.6 trillion US, or 5% of global gross domestic product. So this work that you've done today and will continue to do really will have an impact. In the UK, I'm not sure if you heard this figure earlier on, we estimate organised crime costs at least £24 billion every year. And this drive for beneficial ownership disclosure started at home in the UK, if you like, with a determination from our government to detect and prevent these particular financial crimes, and partly as a means to protect the economy and boost prosperity. So we are spearheading now an international campaign to seek to change global norms on company beneficial ownership transparency. And we've got a date of 2023 to have made progress on that. And this is why we're engaging with you all today. We've also got support from like-minded countries, which includes Argentina, Indonesia, Ghana, and Ukraine. And there's also a lot of support and interest from civil society organisations and international organisations like the World Bank and the IMF. So there's a lot of powerful support behind this. We actually had a first workshop in this programme on the business community, and that had 200 participants, really, really strong interest there. And I think actually the number of law enforcement participants today really shows the drive that's present across all sectors in Trinidad and Tobago to support transparency in business. So I hope that the gap analysis report that you have heard about today and the expertise that have been shared will allow the numerous different agencies that are here today to work together on strengthening some of the areas for development that have been identified, because I think that collective work and trying to get over the silos is something that we've worked really hard to do in the UK, and I think that really will have impact. So let me close by saying lifting this veil of secrecy, if you like, really does disrupt a key vehicle for illicit financial flows and makes a big difference to tackling crime, but also boosting the economy. And we've seen this in the UK. So I really hope that the information and the expertise that was shared today will help further reinforce the implementation of beneficial ownership legislation in Trinidad and Tobago. I wish you all the best of luck in the steps that you take following this workshop to really make a difference and to really move this issue forward into the UK. So I'll stop there and pass back to Sherwin. Thank you very much.
Thank you, Your Excellency. And now it's after that statement, it's really left for me to give a quick vote of thanks. But if you have questions that have not been answered, please send us an email to info@tteiti.com. We will ask Michael, Lee, and Tim to provide any responses. Firstly, I would like to thank our sponsors and partners, the Trinidad and Tobago Transparency Institute and the British High Commission. We have done countless projects sponsored by the High Commission, and we look forward to many more future collaborations. I'd like to thank the facilitators, Michael, Baron, Tim Lowe, and Lee Robbins. I think they gave us all food for thought on how we navigate beneficial ownership disclosure in TNT, how it can help in investigations. I'd like to thank our steering committee, the TTEITI steering committee and secretariat, particularly our project officer, Deandra Grandison, our communication agency, Yellow House Media, and Kerry Peters. Last but not least, I'd like to thank you, the participants, for making this a rich discussion and asking questions and getting feedback. Before I bid you farewell, I just ask that I'd like to let you know that this is not the end of our engagement. We will send each of you a toolkit highlighting some of the issues raised today, along with a recording of the sessions and the presentations. We also have a very brief survey that we want you to complete to give us your feedback on the session. It will help us in terms of designing future sessions like this. So please give us your honest feedback. And thanks again for attending. Please enjoy the rest of your day and everyone be safe. Thank you.